You know, it's a story we've all heard, right? A homeowner wants to make a simple improvement to their property, and suddenly their homeowners association steps in and says, not so fast. But what happens when a seemingly small disagreement over a backyard shed spirals into a full-blown, multi-year legal showdown? Well, we're about to dive into exactly that, how one little structure pitted a family against the rules of their entire community. And right there, that's the heart of it. That's the homeowner, Rosalie Emmons, laying it all out. See, she wasn't just arguing about the shed itself. Her big claim was that the HOA was guilty of selective enforcement, basically applying the rules to her but letting others slide. Now that is a serious accusation, and it completely changes the game from a simple violation to a much deeper question about fairness. So how on earth does a backyard shed lead to an actual legal hearing? Well, it all kicked off when the Emmons family moved into their new home. They had a simple plan: put up a shed for a little extra storage. They had no idea that this one decision would set them on a collision course with their HOA. Now, this thing didn't happen overnight. Let's look at the timeline. In May of 2020, the Emmons family buys their house. Fast forward a year and a half to the fall of 2021, and the shed goes up. And yeah, they admit they didn't get prior approval. By December, that first violation notice hits their mailbox. And that kicks off almost 2 years of back and forth, denials, appeals, and fines piling up, all leading to a formal hearing in August 2023. Okay, let's dig into the homeowner side of this. In a really bold move, Rosalie Emmons decided to represent herself in the hearing. I mean, think about that. No lawyer, just her against the HOA's legal team. And her entire case was built on one single, powerful claim: the HOA was unfairly targeting her family. So how was she going to prove it? Well, this wasn't just some gut feeling she had. No, she did the legwork. Rosalie literally walked her entire neighborhood and took pictures of more than 20 other sheds. Her argument was that many of these also broke the rules. For her, this was the smoking gun, clear proof that sheds were just a normal, accepted part of the community. So her argument really boiled down to a few key things. First, she claimed the HOA had a history of just turning a blind eye to these other sheds, some for years. Second, she believed they only started a big crackdown after she started pushing back legally. She even tried to compromise, offering to raise her fence or plant trees to hide the shed, but the HOA shot down every single idea. And all the while, those fines just kept climbing, hitting almost $1,000. All right, but every story has two sides, right? So what about the HOA? Their rebuttal was pretty straightforward. Rules are rules. From their perspective, the regulations are written down in black and white. They apply to everyone equally, and it's their job to enforce them, to keep the neighborhood looking a certain way. And this slide right here, this really gets to the heart of the whole disconnect. On one side, you have the homeowner's view, which is based on what you see with your own eyes. Hey, sheds are everywhere, so it must be okay. But on the other side, you have the HOA's rulebook, their legally binding documents. And that rule is crystal clear: no construction without prior written approval. In the eyes of the law, there's just no wiggle room in a sentence like that. So the HOA built their defense on a few solid points. 1, the shed was built without approval. That's a fact nobody disputed. 2, it was taller than the fence, which broke another specific rule. 3, and this is a big one, they brought receipts showing they had denied 3 other similar applications, arguing this proved they were being consistent. They also pointed out it violated city code. And finally, they leaned on something called a non-waiver clause. It's basically a legal safety net in their documents that says, hey, even if we missed a violation in the past, it doesn't mean we give up our right to enforce the rule today. Okay, so this all brings us to the main event, the formal administrative hearing. This is where it all goes down. Both sides get to lay out all their evidence, make their final arguments, and then a judge has to decide who's right based on the law and the community's own rulebook. So let's look at the tail of the tape. What did each side bring to the table? Emmons came in with her photos of those 20-plus sheds and her arguments about inconsistent enforcement. The HOA countered with a stack of official documents, their governing rules, the CC&Rs, those denial letters for similar sheds, and the city code. It was really a classic showdown, what you can see in the neighborhood versus what's written down on paper. So, after hearing from both Rosalie Emmons and the HOA's manager, and after digging through all the documents and photos, the administrative law judge was finally ready to make a decision. But wait, before we get to the verdict, there's a really critical legal idea we have to talk about. It's called the burden of proof. And honestly, this is everything. It meant that it wasn't the HOA's job to prove they were being fair. No, the legal responsibility, the burden, was entirely on Rosalie Emmons to provide enough hard evidence to prove they were being selectively unfair. That's a really high bar to clear. And in the end, the judge determined that she had not met that burden. Her petition, her whole case against the Homeowners Association, was dismissed. The judge's own words really spell it out. He wrote that while the homeowner alleged selective enforcement, she ultimately failed to provide sufficient evidence to actually prove it in a court of law. Those photos of other sheds just weren't enough to outweigh the HOA's documented evidence, like those denial letters, which showed a pattern of consistency. At the end of the day, the rulebook won. This whole saga really boils down to one fundamental question, one that anybody who lives in an HOA has probably thought about. On one hand, rules create order and are supposed to protect property values. But on the other, they can feel incredibly rigid and impersonal. So where do you draw the line between consistent, fair rules and the unique circumstances of an individual homeowner? As this case shows, when what you see goes up against what's written down in a legal fight, the written word often has the final say. What do you think the right balance is?